A very good morning to you, colleagues. Let me take this opportunity to welcome you to this session of today. This session has been put together by the BBCBE in order to better understand the thinking from National Treasury, specifically from the colleagues in the Office of the Chief Procurement Officer, the latest draft regulations that have been published by National Treasury, so that we can then be able to prepare ourselves to make a comprehensive submission as requested by National Treasury. Before we go into the detail of why we are here, I'm going to invite the President of the Black Business Council in the Built Environment, Mr. Denny Masimini, to officially welcome us here and to make his opening remarks. President, over to you.
Thank you very much, CEO Ntate Mofokeng, and a very good morning to the colleagues who have joined the webinar, and special greetings to representative of the Office of the Chief Procurement Officer, Mr. Pinenge Sihle Mashabane, and the presenter, Leander Peterson, and your colleagues. Indeed, colleagues, it is a dire moment where at this stage, the procurement space, in particular related to public sector, it is in limbo, which arises from the Constitutional Court judgment between the Minister of Finance and AfriForum, and the two notices that were issued thereafter that judgment, where it is really confusing, where we do have our members who are stuck with a stack of documents with no proper communication coming from the various clients, where some clients who have noticed that they've decided to take out the triple B benefit in their procurement space, and some have just decided to soldier on without changing anything. And indeed, it is a confusing moment. We are aware now, colleagues, that there is a document which is in the public space where we have to do public comments. And this document, the public comments, they are closing on the 11th of April, my apologies. But on that aspect, you know, what we have now is Section 217 of the Constitution that requires that public procurement by the state should be fair and objective, permit organs of state to use public procurement process to achieve economic transformation, and it must take place in the context of a regulatory framework which sets parameters within the transformatory policy of organs of state. And on that aspect, you know, what excites us or what gives us comfort is that whatever happens, the procurement process has to set a target to achieve economic transformation. And in that space, colleagues will be aware that, and maybe our colleagues from the OCPO will also touch on that, where we expected that the public procurement bill, you know, would have been in motion or gazetted and maybe being in full force by now. We don't know what are the delays related to that. Maybe if they can also touch on that. But from where we are sitting, we find the process as if government is not fighting enough, especially Treasury, to make sure that we achieve economic transformation. And we all believe and agree that 28 years into the democracy, we're not even close to that, you know. And the World Bank has released statistics where South Africa is part of some of the southern African countries where there is still inequality. You know, the economy of the country is in the hands of only 10% of the population, you know, and which makes us to really join forces with government to make sure that whatever forces that try to dissuade us, you know, from achieving this project and this objective, we try to fight tooth and nail, you know, in order to achieve that. And in that space, we are comforted and given hope by our counterparts in the KZN who have decided or that they are going to instead take government to court the same way that AfriForum do, to make sure that the BBCBE Act and other factors, you know, that encompasses transformation are still there within the public framework. And on that note, colleagues, let me take this opportunity to welcome you all and welcome our colleagues from the office of the OCPO. And on that note, just to remind them that as BBCBE, we're still waiting for a meeting from the current acting chief procurement officer, you know, which we feel that it is we don't have to be reactive. We have to be in touch all the time, have frequent meeting so that we address as and when issues that relate to procurement, especially in the infrastructure space. So without any waste of time, let me hand over to you, the facilitator, the CEO, Mr. Gregory Mufokeng. Thank you very much. You are all welcome.
Thank you very much, President, for your welcome. Colleagues, now that the President has welcomed us, let me proceed with just a few announcements as far as housekeeping rules are concerned. Number one, we request all participants to mute themselves so that we avoid unnecessary feedback. Number two, we are going to request that those their questions online must utilize the Q&A which is there. So we will see your questions and then read them out, colleagues from National Treasury, to then be in a position to answer those questions. Colleagues, let me take this opportunity then to introduce the delegation from the Office of the Chief Procurement Officer from National Treasury. We have the following representative engaging with us, presenting to us and also responding to our questions. The lead presenter will be Ms. Leanda Peterson, and she is accompanied by Mr. Ntando Matebula, Merahadi Mozeso, as well as Ms. Piwe Mashabani. So those are the four representatives from National Treasury's Office of the Chief Procurement Officer. We welcome you, colleagues, and we are hoping that this will be a fruitful discussion that will then enable us to obviously try and shape your thinking, and also to empower us to be able to make a comprehensive submission to National Treasury as far as the gazetted draft regulations are concerned. Colleagues, the President has already given us the background as to why we are here. We know that the Constitutional Court has made a determination that have declared some aspects of the regulations of the PPFA unconstitutional, and as a result, National Treasury has had to respond. And in responding, the draft regulations have now been gazetted, and we need to engage with those. At the same time, and I'm hoping that the presentation from Ms. Peterson will touch on this, we are now experiencing a lot of challenges in the market because state organs, National Treasury differently. We get mixed signals from various organs of the state. And I'm hoping that the presentation from Ms. Peterson will also clarify some aspects of the communication from National Treasury that will then empower us to engage meaningfully with our clients, because they cannot be a vacuum. We'll be reading from the scheme sheet. Thank you very much, colleagues. And let me then take this opportunity to hand over to Ms. Peterson to proceed with her presentation.
Good morning, Chair. Good morning, colleagues. Good morning, President and CEO. I trust that I'm audible. I unfortunately am not able to put on my video.
Ms. Peterson, we can confirm that you are very much audible. Thank you.
Oh, okay. Thank you. Thank you, Chair. I've been having some serious challenges this morning with technology, so I don't want to tempt fate and put on my video. I'm just going to quickly load the presentation. Quickly, if I can get confirmation as well.
We can definitely see it, ma'am.
Okay, just need to go back quickly then. Right. Thank you very much, and thank you for the warm welcome. As indicated, my other colleagues are also here, so we'll be happy to engage and take questions. We thought that perhaps it would be important before we get to the actual draft regulations to maybe just take a step back and let's talk about the judgment. Maybe a little bit of its genesis, and a brief overview of the judgment, its effect. Maybe just in looking at the overview, we can also just take us a little bit back as to where it started, because I think it's important that when we engage, we have the full picture, and so we can then understand why we are where we are now. We've always enjoyed wonderful discussions of BBCBE, and we expect that this meeting will be no different, and we look forward to that. So essentially, before we even get to the date of the 16th, let me just quickly say, so this matter actually started in about around 2018, when Agribusiness, now Sake Liga, took the Minister of Finance to court, particularly around Regulation 4 and 9, which were the regulations that brought in pre-qualification as a condition of for preferential procurement and subcontracting as a condition of tender. They also challenged other provisions like the criteria for breaking deadlock and so on, but that was dismissed. At the High Court, the judge, when he upheld the minister, he said that the regulations were not ultra vires, and he dismissed Agribusiness's case. He actually mentioned that he found almost that the application by Agribusiness was somewhat, and I'm paraphrasing, but somewhat disingenuous, in the sense that the regulations that they were challenging, pre-qualification, subcontracting as a condition of tender, were regulations that are sort of an antecedent step, a step before your price and preference. But in the same way that is a step before price and preference, so is functionality. But that was not challenged. And the judge felt that the reason that they were challenging pre-qualification and subcontracting was because their members were not part of the group that stood to benefit by these regulations. So it's just interesting, I think, that we need to just understand what is being challenged and why it's being challenged, or in the sense that what is the implications of that challenge, and why we need to be careful sometimes about even our own understanding of some of these things, but we'll get to that. And then then they applied for leave to appeal. The judge actually didn't grant them leave to appeal, and they petitioned the Supreme Court of Appeal. The Supreme Court of Appeal then indicated that Regulation 3B, 4 and 9 of the regulations are unlawful. And they then said that what they held to be the interconnectedness of the regulations, that you can't sort of read them in isolation, they are interconnected, and therefore they declared then the entire set of the 2017 regulations was declared invalid. And on the basis that the regulations exceeded what may be regulated in terms of Section 5 of the Procurement Act, and they even went as far as saying it exceeded what is provided for in terms of Section 217 of the Constitution. But the declaration of invalidity was suspended for 12 months to give the Minister of Finance an opportunity to now correct what they held were invalid provisions. But then the Minister of Finance launched an appeal at the Constitutional Court. And there is a provision in the Superior Courts Act, Section 18(1), that allows that when an appeal is launched, then it suspends the order of the lower court. So when that appeal was launched, it suspended then that order that the Supreme Court had given. So in other words, the 12 months then, from the time that the minister launched the appeal, the 12 months stopped running. And then we were then waiting, obviously, with bated breath for the judgment of the Constitutional Court. And on the 16th of February, the Constitutional Court then handed down judgment in that application for leave to appeal. So it was a dual kind of finding. On the one hand, they granted leave to appeal, but then they also made the finding on the appeal. So on the appeal, they said that they then dismissed the minister's appeal, and they also then said that the 2017 regulations were held to be invalid. But interestingly enough, the majority judgment, so as you know, there was a split decision. It was a 4-5 split. The majority judgment then was silent. In fact, both judgments were actually silent on the question of remedy, except to the extent that I'll tell you now. But they didn't, so in other words, the majority judgment, which is the judgment we're concerned with, did not pronounce on the issue of the suspension. And ordinarily, if they didn't do that, it wouldn't have been a train smash, because of Section 18 of the Superior Courts Act that I just mentioned now. So in other words, when the majority judgment was handed down, Section 18 then would be engaged, and in meaning that now, since the Constitutional Court dismissed the appeal of the minister, it then meant that the order of the Supreme Court would be re-engaged. So in other words, the suspensive period would now recommence, and the suspension of the invalidity would continue for the remaining period of the judgment. So that's what ordinarily would happen. And any person reading that would have that understanding. But what threw a spoke in the works was that in the minority judgment, there was a footnote. In footnote 28, the minority judgment had indicated that the period of suspension expired on 2nd November 2021. And that is where, and that is in conflict with Section 18 of the Superior Courts Act. And that is where the confusion has now set in. And so, and if you look at it, of course, neither the minority judgment nor the majority judgment purports to set aside or replace the Supreme Court of Appeals order. It leaves this conundrum. And it's because the Concord simply just confined itself to granting the minister leave to appeal and to dismissing the appeal against the Supreme Court's position. So now, even though ordinarily the legal position would be that the Supreme Court of Appeals order is no longer suspended, it now can re-engage, but because of the footnote, there's that confusion. And that is why the minister now has, on an urgent basis, sought confirmation from the Constitutional Court that the invalidity of the regulations has been and continues to be suspended, and to just give us that clarity that, okay, is that the case? And if so, is it then running until the remaining period of the suspension? But obviously, while there's this clarity that is being sought, it now leaves organs of state in a bit of a dilemma, because if the Constitutional Court had to come back and say, no, the suspension has come to an end, but it's come to an end on the 16th of February, the day the judgment is handed down, where does that leave tenders that need to be advertised from the 16th of February going forward. The other slight, although not a probability and probably highly unlikely, is that the Constitutional Court can come back and confirm the 2nd of November. But I doubt that, well, most legal people doubt that that would be the position. And in fact, there was a High Court judgment that was released just yesterday, which tends to reinforce that invalidity will not be, won't happen retrospectively. But again, like we say, it's still important that we get the confirmation from the Constitutional Court. But because of that, that's when National Treasury issued advisory communication. Again, not binding in nature, just saying to institutions, alerting them to the fact that there has been this judgment, and that if a tender was advertised before the 16th of February, it may continue to be evaluated in terms of the 2017 regulations, because it would have been advertised in terms of those regulations, and it was prior to the judgment being handed down. And like I say, the judgment that was handed down yesterday in the Western Cape High Court also tends to support that position. But then tenders advertised on or after the 16th of February were advised that if possible, it would be better to rather hold them in abeyance. Now, we know that that is not necessarily always possible, but sort of saying, look, if you can hold back, maybe just wait for the Constitutional Court's confirmation, and then preferably try not to advertise, apologies, any new tenders going forward until we get that confirmation. But of course, institutions were very concerned and were worried that this is now going to put a stop to service delivery. And that is why there was a second communication explaining that the National Treasury was not instructing, in fact, cannot even be in a position to tell people to stop, because remember, accountability and responsibility is vested in the accounting officers and accounting authorities for their institutions. But was also then saying, look, in terms of the request for guidance, because institutions are saying, but how do we carry on then in the meantime? And so the second advisory communication was simply explaining that, look, even if you look at quotations, because the formula applied to quotations from 30,000 and above, and applied, for your 80-20 and your 90-10, if the regulations are now declared invalid, on what basis would you be evaluating? Because there's no longer a formula and there's no longer a threshold amount. Because if you look at section 2.1 of the triple PFA, it talks to 2.1b, talks to threshold amounts, and 2.1c talks about a formula. And in both cases, the threshold amounts must be prescribed and the formula must be prescribed. And prescribed in the definitions of the triple PFA says prescribed by regulation. So when you look at it, even if an organ of state has a policy in place, they would not be able to, that policy would have a gap, because it cannot be, the organ of state cannot prescribe the threshold amounts by policy or prescribe a formula by policy. That has to be prescribed in regulations. And so it was on that basis then that Treasury then also indicated that institutions may also then approach the National Treasury, the Minister of Finance, to request for exemption if they want to continue with certain procurement that really cannot, that cannot wait. And again, when we were discussing what are possible ways that we can help institutions overcome this temporary conundrum, one of the things we discussed was why doesn't the minister maybe issue a blanket exemption to institutions so that they can continue running in the meantime and have service, and that service delivery doesn't stop. But we very quickly realized that in terms of the legislation, section 3 of the triple PFA, which is the section that talks to exemptions, says the minister may, on request, grant an exemption to an organ of state. So it's an organ of state that has to request that exemption. It's not even, a provincial treasury on behalf of its institutions. It's not a mother department on behalf, a parent department on behalf of the other departments. It has to be an organ of state that requests. And then also, some institutions have actually indicated that they don't even want an exemption necessarily. They are happy to take their chances to use the 2017 regulations, because they don't believe that the court would actually come back and say that the suspension has stopped. They say that they are looking at Section 18(1) of the Superior Courts Act, and they say they believe that the logical sort of response from the Constitutional Court will be that the suspensive period has been re-engaged. So some don't even want an exemption. So it's on that basis that we cannot really even force institutions anyway. We can't just blanketly exempt them. They need to then request that. So I think those were, and so that is why that second communication was issued, and then also informing institutions that in the meantime, draft regulations are being prepared. And in fact, since that, as you are well aware, those draft regulations were then published on the 10th of March in the National Gazette and in all 9 provincial gazettes. And they essentially provide for those threshold amounts that I spoke about that have to be prescribed, as well as the formula that has to be prescribed. But then if you look at Section 5 of the Act, it also says that the minister has the power to make regulations on any matter that may be necessary or expedient to be prescribed in order to achieve the objects of the Act. And so it's on this basis that the draft regulations were then developed and published. And in terms of the Constitutional Court, the clarity that the minister is seeking, papers were actually filed at the Constitutional Court on Friday. And believe it or not, it was already opposed. Because although it's an ex parte application, meaning it doesn't necessarily involve other parties, but because other parties were involved in the actual case, they needed to be notified. And in fact, there's already been opposition by one of them for that clarity. It's almost hard to believe that people wouldn't want clarity to be sought, but be that as it may, there's already opposition, and we've been given until today, the 2 parties, to then file the necessary replying affidavits, answering affidavits, heads of argument, etc. So at least the fact that there's movement by the Constitutional Court, albeit that we can never guarantee how long such cases will take, even though it's on an urgent basis, at least gives comfort that there is some progress. So before I get to now the actual slides, which is the next slide, I just want to stop a little bit and pause on that concept of necessary or expedient, because that is where the judgment turned. If the judgment turned on that concept. So if you had and I trust it would be really great if everyone has read the judgment, but if you look at the judgment, you'll see that the minority judgment took a number of the pages, took a lot of the judgment. A lot of the judgment was spent on the minority judgment, and it set out very nicely the arguments by the minister, and ultimately, in terms of the minority judgment, there was that understanding that the regulations do in fact do what Section 2172 requires them to do. And if you look at the majority judgment, and this is what we feel it important that it must be mentioned, colleagues, that the Constitutional Court differed from the Supreme Court of Appeal in its reasoning for the judgment. So its rationale for why it declared the regulations invalid was very different to the rationale of the Supreme Court of Appeal. So whilst the Supreme Court of Appeal held that regulations 3B, 4, and 9 were invalid, were unlawful, the Constitutional Court didn't have the same finding. What the Constitutional Court turned on, and this is what the majority judgment turned on, they said, even though, and happily, in fact, in paragraph 616, they say happily, the minority judgment, the majority judgment, and indeed even the minister understand the impugned regulations to be doing what Section 2172 of the Constitution requires. They say the only difference is that it shouldn't have been the Minister of Finance who was doing that. That should have been in the domain of the organs of state. And the reason they say this, they say that because Section 2.1 of the PPPFA says that an organ of state must determine and apply and implement preferential procurement policies in terms of the framework, it was then that determination to come up with the preferential procurement policy has been given over to the organs of state. So they said that it was not, even if the Minister of Finance felt that organs of state are not doing what they're supposed to be doing, it was not his place to aggregate to himself that responsibility to now step into that domain and make the policy for them. They said so the majority judgment says it was not necessary or expedient for the Minister to do what an organ of state should have been doing. And whereas the minority judgment said that they believe it was necessary and expedient for the Minister to do what he was supposed to do. So what I'm trying to say, colleagues, is that unlike the Supreme Court of Appeal that said that 4 and 9 were unlawful, the Constitutional Court didn't have a problem with those regulations. They simply had a problem with who was doing that. So if an organ of state, for example, and this is the way we read that judgment, that if and this is how a number of legal people read it as well, that if an organ of state, for example, were to put in their own policies issues relating to what was contained in 4 and 9, they can't see how there would be a problem with that, because that is in keeping, it's aligning to the objects of the Act, which are aligned to Section 2172 of the Constitution. So that I thought it was important, because I think from time to time, we often hear in discussions this sort of reference back to, but why don't we just take out 4 and 9 and leave everything else in? And yet 4 and 9 by the Constitutional Court were not even challenged or declared unlawful. They still were unassailed. It's the fact that it wasn't the Minister's place to put in all those various things that he was putting in the regulations in the first place, because the organs of state should have done that. And we'll get, now that we talk now specifically on the regulations itself, we'll then start understanding, when we unpack this now, why certain things were then left out, and also why certain things that were viewed to be good might not necessarily have been achieving the objects of the Act. Okay, so again, as I said, so as a rationale, as a broad principle rationale, the idea was then, firstly, the regulations must regulate on matters that the Act says they must regulate on. And the very obvious and distinct ones, explicit ones, are then the threshold amounts in 2.1b and the formula in 2.1c of the Act. And then also, like we say, other things in Section 5.1 that are deemed to be necessary or expedient. But of course, learning lessons from the judgments, from the High Court through the Superior Court of Appeal through to the Constitutional Court. So if you look then at so some of the matters that were in the 2017 regulations are no longer in these 2022 draft regulations, because some of them can actually be regulated. Some don't actually even fall within the ambit of preferential procurement, and they can actually be regulated elsewhere in the broader SCM frameworks of institutions, either in their policies or in an instruction, maybe in terms of the PFMA, or in a regulation or the policy of an institution in terms of the MFMA. So let's look at it. I think this one is the one that has firstly created a lot of attention, and I think the President in his opening remarks mentioned it as well. So you'll see there, you would have noticed then, that reference to the use of BEE status as a specified goal to be used when allocating preferential points has been omitted. Apologies, colleagues, I just want to cough for a moment. you. So again, firstly, if we look at section 2.1, we see that it requires an organ of state, as I said, to determine its own preferential procurement policy and to implement it within the framework prescribed in the Act. And if we look at what does the Act prescribe, if we look at section 2.1d, it says that an organ of state must include in its policy specific goals that relate to persons that have been historically disadvantaged by unfair discrimination. So if we look at that, and then it goes on to talk about, it talks to Black persons, it talks to female-owned enterprises, talks to persons with disabilities. So if we look at that, and if we bear in mind that the PPPFA has been developed in terms of section 2173 of the Constitution. So if you just allow me a moment, section 2172 of the Constitution, remember, says that an organ of state must implement its preferential procurement policy and may provide for categories of preference in the allocation of contracts and provide for the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. And then it goes on to say in 2173 that national legislation must prescribe the framework in which the policy referred to in subsection 2 may be implemented. And so remember now, so the PPPFA is that national legislation that is prescribing how organs of state must give effect to 2172. And so when we look at 2.1d, it talks about, again, it has a line of sight to the Constitution. It talks about persons who are historically disadvantaged by unfair discrimination. And then 2.1e says that an organ of state must, in the invitation to submit a tender, so when it's requesting quotations, when it's inviting for competitive bids, that organ of state must clearly specify the specific goals for which a point may be awarded. So now, when we so that's the first iteration of the regulations. Fast forward to 2011, we find now that whole provision where an organ of state has the ability to say, you know what, for this tender, enterprises in this space in which we operate, enterprises owned by Black people are really there's hardly any market for enterprises owned by Black people. So for this tender, we are going to actually give all 20 points or all 10 points to enterprises owned by Black people, not an enterprise that is owned by a white person who's got a BEE status level of 1 because he has done enterprise development and he's done supply development and so on. The Constitution is saying you need to focus on protection or advancement of persons or categories of persons previously disadvantaged by unfair discrimination, not on persons who are assisting by giving you some training or giving you supply development or enterprise development and still getting the tender. So this is about saying, start allowing procurement to be used as a lever to actually empower people who were disadvantaged by unfair discrimination, female-owned enterprises, enterprises owned by persons with disabilities. And then 2.1d, Roman numeral 2, also talks to goals relating to programs of the reconstruction and development program. So in other words, the focus then is on what can we do? How can we use procurement as a lever to start giving that added boost to those enterprises that have been struggling because of unfair discrimination? So, and what BEE status of a level of contributor then did is supposedly roll up all these goals into one, but you can't see it. So you're not able to give a specific point for a particular goal. So actually, if we look at the way it was applied in the regulations, it actually suggests that by replacing that, so it's not even with Black economic empowerment, it's replacing it with broad-based Black economic empowerment. So it doesn't give you an opportunity to allocate a particular point for a specified goal. You now are forced to allocate a point on the basis of your BEE status level. So you then find that maybe that same enterprise that is not disadvantaged by unfair discrimination before that same enterprise is now saying, can come along and say, no, here's my BEE status level. I'm a BEE status level 1. So that enterprise gets 20 points or 10 points for BEE status, and then still wins on price because they are well established and they're able to then use the economies of scale and give a good price. And this is why the likes, I think, of BBC and even other state-owned enterprises were saying, and other organs of state were saying, but the 2011 regulations are not taking us any further. But yet we didn't, the focus was not on looking at saying, but let's go back to the Act and let's align with what the Act has said. So if we look even, and remember, there is a BEE, a BBCBE Act that's in place, that's run, that's mandated to be administered and so on by another organ of state, our DTIC. And when the court case, when the Supreme Court of Appeal judgment came out, the BBCBE Commission came out very clearly that they're not affected by the judgment, because BEE continues to still be run in terms of the BEE Act. So in any case, that then also indicates that really, because the Section 10 of the BEE Act states that every organ of state and public entity must consider, and as far as reasonably possible, apply any relevant codes of good practice issued in terms of the Broad-Based Black Economic Empowerment Act in developing and implementing a preferential procurement policy. So that means that that act has already also recognized that institutions, when they're working on their policy, they can also apply or look at the codes of good practice. So therefore, there's a separate act that already looks at BEE. So by introducing BEE, BBCBE, into the regulations that are meant to look at specific goals and look at that line of sight to 2172 of the Constitution, by introducing BEE, the minister was stepping into an area that technically wasn't even his domain and was an overreach. And in fact, the unintended consequences of that was that actually, you know, the question needs to then be asked, what were the regulations actually empowering persons who were historically disadvantaged by unfair discrimination, or was it now inadvertently actually empowering the already empowered? So, and when we look at it purely even from a legal perspective, besides even the ideological perspectives, we can see that in any case, the minister had no place in bringing in the BEE regulations the way it was done. It needed to be focused on historically disadvantaged individuals. It needed to be focused on redress, not on already giving points to people who have already been empowered. For some reason, my slides don't want to move. Maybe I must just stop for a second and reshare. Apologies for that. Sorry, colleagues. It doesn't want, oh, there we go. Great. Okay, so I think I've spoken at length about that, but we can obviously still have discussion. And then the other omission that you'll see in the regulations is the reference then to local production and content. In the previous regulations, in 2011 as well as in 2017, and there was a provision for local production and content, but again, this has been omitted because it's outside the scope of the Act and the minister's regulation-making authority. Because remember, as I mentioned, in the framework, we talk in 2.1d, Roman numeral 1, we talk about your historically disadvantaged individuals, your females, your persons with disabilities, and 2.1d, Roman numeral 2, talks to the implementing the goals of the RDP. But it does not provide for local production and content to be used as a disqualification criterion. So again, this is something that should be in the domain of the policy owners. And again, but even then, remember it says the organ of state must determine its preferential procurement policy and implemented within the framework that is set out in section 2, in section 2.1. So if you look at that framework, it allows you then to allocate your points for specific goals, and local production and content. Organs of state need to look within those the RDP program and determine how they can then make use of the aspirational objectives contained there and translate them into their policies and into their tender documents. So they might then indicate that for this particular tender, we want to award 10 points or 15 points or 18 points to enterprises that are producing and manufacturing locally. But that would then be up to them to then determine that in their policy. Again, it cannot be the minister who extracts certain goals from that document and then force institutions to utilize that. Because again, if we look at what the Constitutional Court is saying, he'll be overstepping his domain. The other thing that the Constitutional Court has said, by the way, sorry, while I'm thinking about it, is that where the minister felt that organs of state were not maybe following their policy the way they ought to have, or utilizing their powers the way they ought to have, the court said the minister needed to find legally cognizable means. So, and they even said that means sort of maybe talking to his political counterparts, if he feels that, so to sort of say, guys, speak to your institutions to relook at their policies, to make provision for this, etc. Or then he should have changed the law. If he felt that the law is maybe not achieving what it ought to be, then change the law. But you cannot simply on your own step into a domain that you're not required to. But so on local production and content as well, again, it's not, you won't find it in the regulations the way it's been in its previous iterations of the 2011 and 2017 regulations, simply because, again, we're looking at what did the court say. Furthermore, even if we had to go back and look at the Supreme Court of Appeal decision, even there, if you look at the rationale for the Supreme Court of Appeal decision for saying that regulation 4 and 9 shouldn't have been there, then if we apply that same logic, which, like I say, the Constitutional Court differed in any case, but if we apply that logic, then local production and content cannot be used as a disqualification criterion, because it would then be that antecedent step that the court was talking about. So, but again, like I say, the Constitutional Court differed altogether, in fact, but specifically with the focus on 4 and 9, and was saying that the minister just must not overstep his authority. Functionality, I know, again, people panic when they see that functionality hasn't been included. And this, again, is not because functionality is not important. Functionality being the ability and capability of a bidder to do the job. It's important that functionality must take place, but it's not a construct of preferential procurement. Preferential procurement, again, and I think we have to constantly remind ourselves, preferential procurement is about redressing the imbalances of the past. It's about having that line of sight to the Constitution. It's about looking at persons or categories of persons disadvantaged by unfair discrimination. So functionality technically doesn't belong in preferential procurement regulations. So it is something that an organ of state can determine on their own in terms of what are the criteria they would want to look at, what would be the approach, bearing in mind that the PPPFA does talk about acceptable tender. So in other words, before you can get to price and preference, you need to look at whether or not that tender is an acceptable tender. Does it meet the specifications and criteria of the requirements in that tender? But then also, alternatively, like we say, because we know as well that sometimes institutions might have some kind of difficulty sometimes when it comes to the broader SCM framework, nothing precludes the minister, because National Treasury has also been mandated to provide for norms and standards, looking at the way you would manage what has been allocated to the state. So when we look at that, it can also then be prescribed in terms of an instruction under Section 76 of the PFMA or even a regulation in the MFMA, amending the regulations, or also by municipalities adopting that in their SEM policies. So if it's where there isn't any restriction, nothing stops them then from adopting certain provisions in their policies. And then the others are going to go fairly quick, colleagues. But so if we look at, for example, you'll see there's no longer a provision for subcontracting after the award or cancellation of tenders. These are important provisions to be looked at, but they just don't belong in preferential procurement. They're outside the scope of the Act. And similarly, as I said, they can be managed in the broader SEM prescripts. If we look also then pre-qualification for preferential procurement and subcontracting as a condition of tender, the regulations that actually brought about all the hype and the excitement, they've been omitted again, but not because they are unconstitutional, but because these are provisions that are not deemed to be necessary or expedient to be prescribed by the minister and should actually have been left to organs of state to determine in their preferential procurement policies. And then even issuance of circulars or guidelines. Remember, largely circulars were issued to explain about designations, designated sectors and local production and content matters. So obviously, because that is no longer in the domain of the regulations, the need to issue circulars has been quite significantly reduced. But also, even if there is a requirement to issue a circular or a guideline, because they're not binding in nature, there doesn't have to be a specific provision in regulations for them to be issued. And they can merely be issued as guidance anyway. And also a lot of the requirements that have been omitted will be something that can form the subject of an institutional policy. So there won't really be a need for Treasury to be issuing circulars about that. Then you'll see that there is a new provision that hasn't been in the 2017 regulations. And that is a provision that relates to the formula for your income generating tenders and your disposal and your leasing of state assets. So most often, a lot of the contracts, in a lot of the state contracts, it's the state that pays for the goods and services. So this is a cost to the fiscus. But if you look at the triple PFA and you apply a purposeful interpretation of the Act, you'll see that the same principles for awarding points for price and specific goals is also applicable to the disposal and leasing of state assets and other income generating procurement. And you'll see that this came to the fore in the AXA Airports Company South Africa versus Imperial, where the Supreme Court of Appeal basically explained the legal position of the application of the point system on lease tenders, and basically supporting the position that the current formula can simply be used in reverse. And so this is why it's been provided for. So it was deemed to be necessary and expedient, since it was even held even at the court that, in fact, even when you come to disposal and leasing of state assets, you should still make provision for empowerment objectives. Because remember, a lot of the time, people would just dispose of assets maybe and look at the highest points, the highest price that they'd get. But now the court is saying, even when you dispose, it's still an opportunity to provide for empowerment. So you'll see that even in these regulations, contrary to the belief sometimes that it's taking empowerment backwards, it's actually, in fact, further enhancing the opportunities for organs of state to empower. And again, not by means of a broad-based Black economic empowerment certificate, but by allocating points specifically to persons who have been historically disadvantaged by unfair discrimination. So, and then lastly, if we look at the definition section, obviously you'll see it's a lot shorter, and that makes sense because it's been adjusted accordingly and revised accordingly to basically eliminate terms that no longer appear in the regulations. And also where there are terms maybe that on the face of it might seem that, but why don't we define those terms? If, unless the context would specifically indicate otherwise, there was no need to define such terms, because they would have been ascribed their specific definition, in any case, their ordinary meaning. So if you look in the dictionary and that's what it means, then that's the meaning that is ascribed to it. It's ordinary meaning. There's no particular need for a special definition. Then just in terms of the way forward, as we know, so the regulations were published on the website and in the gazettes of the 9 provinces, and the closing date is then the 11th of April, and you'll see that's the email address to which comments should be sent. Also, because I mentioned, remember, I also mentioned that organs of state can request for exemption. Then they can, that request must be addressed to the minister, but it can be sent to the CPO at treasury.gov.za. And even the subsequent maybe questions around that must be sent to that address. Then there's also been an email address that has been specifically set up for queries that people might have relating to the Constitutional Court judgment. And that's the email address that can be used. But we have also in the interim, like I said, been doing quite a lot of presentations. So we're hoping to sort of reduce maybe the need for so many questions, so that people can actually ask their questions at these various platforms. And it's better, of course, if emails can be sent there and not to the individual email boxes, because the team is working diligently to try and reduce those queries, and might not always get to their own emails on time, especially if there's duplication, because it will make it difficult to wade through that. In the short to medium term, so obviously once the email addresses, once the closing date for comment arrives, then in fact we're trying to start even to review some of the comments already, but it's also difficult with trying to get through the queries and various engagements. So, but once the 11th sort of sets in, because we believe the bulk of the queries will probably arrive by that time, we'll then need to review the comments. We'll need to review the public comments and revise the draft regulations. Depending on the nature of the comments or the volume of them, it might happen quicker or slower depending on how much we receive. And then the idea is to hopefully promulgate for implementation, and when necessary to maybe induct and orientate organs of state on the new regulations. But because it's very few, it might not be the same level of induction as previously. And then in the medium to long term, because of the topical nature and the objectives that the framework needs to achieve, there's an option, but it's still being canvassed. So please don't indicate that National Treasury is now going to do this. I'm just sharing we're taking the meeting into our confidence to say that one of the issues that we're looking at is maybe to try to fast track Chapter 4 of the bill, because the rest of the team that's working on the bill, by the way, is not here. But I know that in previous meetings, the acting CPO has indicated that there's a bit of a delay in moving forward with the bill based on the Zondo Commission reports, and then also looking at the outcome of the Constitutional Court case to sort of determine, does the bill sufficiently cater maybe for issues that have been raised in the Zondo Commission reports? And so then there's a school of thought that's saying maybe we should then extract Chapter 4, the chapter that deals with empowerment with preferential procurement, maybe try to fast track that separately. And then when the rest of the bill is ready, maybe see if it cannot be integrated back into the bill. But it's not necessarily something that's a fait accompli. It's just a possibility to sort of see, maybe is that a prudent way to go? So that's in the medium to long term. But I think that's it for now, colleagues. I've spoken a mouthful. I'm sure you are quite happy to hear another voice. But for now, I want to say thank you for allowing us the opportunity to share that. Thank you very much.
Thank you very much, Ms. Peterson, for that very comprehensive presentation. And I'm hoping that this 1 hour almost that is left, we will be able to have a meaningful engagement with all the attendees on the platform. And we will start without any further waste of time, colleagues, with the Q&A, focusing firstly on the Q&A chat box, as we had requested earlier that people should post their questions on the Q&A so that we can then be able to respond to those. I see that the office has already sent me some of the questions here, and I will go through them so that we can then give an opportunity to our colleagues from National Treasury, and I've already introduced the panel earlier. I'm hoping that then the panel can also assist Ms. Peterson, excuse me, in terms of responding to these questions. The first question will come from Mr. Robert Semenya. Does the Concord judgment stop organs of state to do procurement for over 30,000 bids without the triple B requirements? Basically, bidders compete only on price, and this will avoid service delivery being delayed pending clarity or promulgation for the new regulations. Ms. Peterson, let me hand over that to you in the meantime, whilst I'm just going through the rest of the questions that came through the Q&A chat box. So the question in essence is, can the state organs proceed with the procurement of bids over 30,000 rands without the BE requirements, and allow people basically just to compete on price and functionality? Over to you, Ms. Peterson, or any of your panel members.
Thank you, Chair. I was also just going through some of the comments in the chat as well. But maybe just to firstly start with that question, and like I said, I have my colleagues, Mr. Nkosino Tando Matibula, Tando, Ms. Rakhadi Motseto, and Ms. Pibengesihle Mashabani. So they're also welcome, as you've indicated, Chair, to step in. But maybe I'll start with the first one. So as we've indicated, the only way at this point in time, if an organ of state if an organ of state doesn't want to continue or feels that it would be too much of a risk to continue with the 2017 regulations pending the outcome of the Constitutional Court clarity or confirmation, then that organ of state, in order to do that type of procurement, even if it's in the quotation space, will still require an exemption from National Treasury. Because remember, as I said, on what basis they cannot simply dispense with the requirements for price and preference or with the formula, because the Act, unless they request for exemption from the triple PFA itself, they would not be able to continue with such procurement because they haven't been exempted from following the requirements of that Act. So remember, the requirements of the Act are that a preference point system must be followed. And the difficulty, and I see in some of, I've just scanned through some of the comments in the chat, at this point in time, in the absence of a change of legislation, organs of state are not at liberty to even change the point system to have a 70-30 or a 60-40. They have to follow, the Act says you must follow an 80-20 or a 90-10 point system. The only thing is that the Act then also says, but the thresholds for that 80-20 or 90-10 must be prescribed. So for example, if you are procuring something for 50,000, apologies, what threshold, what point system will you use? Yes, the Act says 80-20 or 90-10, but in the absence of those threshold amounts being applied, it would be very, an organ of state won't have any idea as to, can I use 80-20 or can I use 90-10? Because if the regulations that are prescribed that are declared invalid and we don't have the clarity yet from the Constitutional Court, what point system would I use? Because what if there was a threshold for it? What if the minister would have prescribed a threshold of 30,000 to 50,000 for 80-20 and 50,000 upwards for 90-10? So I'm just saying, I'm using a ridiculous example, but I'm saying that in the absence of that, it makes it difficult. You cannot, you would not be able to simply dispense with it and follow your own method of evaluation, because unless you are exempted from using that legislation, that means that legislation still applies to the organ of state. So in the absence of an exemption, you cannot just dispense with those requirements because they are in the Act, not in the regulations. So it's the Act that says you must follow a 80-20 or 90-10 point system. So, and hence the advice that if you're not going to take your chances and use the 2017 regulations, the most maybe sort of cautious approach would be to approach the minister for an exemption. And then just to sort of, to explain that it's the 80-20 and the 90-10 that is required in the Act, not, and that's why it's not a case, and it's not that BEE is still there. Goals, specific goals are what is, so please, the Act is a very short Act, colleagues. It's about 2.5 pages, two pages, 1.5 or 1 3/4 pages, so almost 2 pages in total. It's a very short Act. If you look at section 2, you will see that it talks to your goals. For 2.1d Roman numeral 1 and Roman numeral 2 talk about goals, not broad-based Black economic empowerment. So it's not that BEE is still there, it's specified goals, and it's those goals. So if I can put it this way, and sorry, I'm sort of jumping to, I think, a comment I may have seen in the chat. So it's a case of saying, I, as Leander Peterson, as a Black female, am responding to this tender. My question is, if those of us who might be wanting to call and say, but bring back broad-based Black economic empowerment in our evaluation instead of specific goals, am I then saying, I, as Leander Peterson, as a Black female, would rather that you evaluate my bid not on the basis of me being previously disadvantaged by unfair discrimination. So I don't want you to allocate me a specific goal, as the Act says, but I would rather let you look at my broad-based Black economic empowerment status, which doesn't look at me that has been previously disadvantaged, but it looks at what me, 25% of me, my previous disadvantaged status, will go into that certificate. And then the other portion will be, how much am I doing in terms of maybe training, or how much procurement am I buying from other Black people, and how much supply development. Those are all good things, don't get me wrong. I'm not saying we don't have a responsibility as human beings and corporate citizens to do that. But I'm saying, so when you look at all of that, my empowerment status now comes back as a level 2. So if you were going to evaluate me in terms of the goals that are set out in the Preferential Procurement Policy Framework Act, and believe me, the Act does have its own challenges, but if you look at its requirements in terms of your specific goals, I would rather then be evaluated as a person. I would rather be recognized that I need redressing by virtue of my historically disadvantaged by unfair discrimination status, than by the fact that I'm now, instead of getting 20 points, I now might only get 18 points because my broad-based Black economic empowerment status, I didn't do enough. And whereas my friend, Corneille, might get 20 points, even though Corneille hasn't experienced the hardships that I might have experienced by apartheid. But because Corneille has done enough in terms of supply development, etc., Corneille now gets 20 points and I only get 18 points. So I'm just trying to put it very simplistically, colleagues. But anyway, let's stop there. Thank you.
Thank you very much, Ms. Peterson. Let me then, because I think it will be easier, colleagues, if we just allow people that have asked questions on the chat box to present their questions on the platform. I'm going to recognize Mr. Thabo Masombuka, followed by Mr. Bafana Dube, in that order to put forward their questions whilst we are getting the other participants ready to ask their questions. I'm just going through the comments and the questions on the chat box, and we will be bringing in those individuals so that they can be able to elaborate on their questions that they have posed. For now, let me open to Mr. Masombuka and Mr. Bafana Dube for their questions in that order. Gentlemen, let's be mindful of time, colleagues. We've got just 45 minutes now left, and we need to open to as many participants as possible so that at least we can be able to accommodate as many people as possible. Mr. Masombuka, over to you, sir. Okay, it seems as if Mr. Masombuka is not ready yet, or maybe he's experiencing some technical challenges. Can I then hand over to Mr. Bafana Dube to present this question? Mr. Dube?
1 2 1 2.
Okay, Mr. Masombuka, we can now hear you. Please come through.
Yeah, no, the host had muted me, Chair. Look, just a brief one, Chair. I think we must be thankful for the comprehensive nature in the presentation. It does, to a certain extent, try to cover a whole lot of things that have presented a dilemma. But here is a quick thing that I want Ms. Peterson to take into account, and I think which presents the plethora of crisis or confusion as witnessed by the likes of Transnet and others. I don't think we should underestimate the extent to which organs of state, and by now I'm sure we agree that organs of states are inclusive of your national, provincial, local government departments, including their entities. The extent to which they place reliance on whatever communication comes from the National Treasury. Precisely because, for two reasons. One, it's capacity issue, capacity to comprehend the complex nature of procurement. But secondly, because as the purse holder, most of them are worried about what is called audit implication, all right? So whilst we do agree that the Constitutional Court in its conclusion did not say anything about what we call transformative imperatives, which are your section 217, subsection 2 issues, the empowerment, transformation, persons historically disadvantaged because of unfair discrimination. And I do accept that your comments and your presentation elevate the discussion on whether BE and the BE certification in its own does in fact amount to mechanism to redress, because BE is just one part and instrument. There's also issues of local contracting. There's also issues of youth, rural. There's issues of women, people with disability. And I accept that BE and the certificate issued under BE may not necessarily comprehensively deal with those.
Mr. Masombuka, there's a complaint that people can't hear you. Can you please raise your voice or speak closer to your mic, please?
Thank you. Am I better audible now?
I'm hoping you are better audible, and if you can maybe just expedite the question as well. Thank you.
Yes, the question and comment, perhaps, Chair, is that shouldn't the National Treasury, instead of issuing advisory notes, having regard to the fact that there's much reliance placed by organs of states on the directives of the National Treasury, shouldn't National Treasury be issuing guidance? Because otherwise the policy responsibility in this space still resides with the National Treasury. Now the issuers of organs, of procurement policy, as what the Constitutional Court said, still resides with the organs of state. Shouldn't we, instead of just issuing advisory notes, issuing guidelines to help organs of states in areas where they may not have capacity to develop their professional procurement policy that is aligned to the outcome of the court, and also taking into account Section 2172 transformation imperatives. Thanks, Chair.
Thank you, Mr. Masombuka. Mr. Bafana Dube, the floor is yours.
Hi, Chair. Can you hear me?
Yes, we can hear you, Mr. Dube. Please proceed. And
Yeah,
please
Chair.
be short.
Chair, to me, I think from what has been presented by Ms. Peterson, it's clear that government doesn't take Black people seriously. I'm saying the Constitution allows government to be able to use the Constitution to be able to empower the previous disadvantage. And government in 28 years, Chair, they failed to able to use the levers, the laws, in order to make sure that Black people are being empowered. When you look at the report, as the President mentioned, that in 28 years, then the 10% still owns the 90% of the economy, but we've got the 700 billion rands that it's utilized by government on the fiscals to empower Black people. Then down the line in 28 years, government has failed to utilize the law to be able to empower Black people. For me, I'm saying, I just have a fatigue, Chair, of this discussion after discussion where Black Business Council and then BBCBE meets with government and have these lengthy discussions. Now we're interpreting the law, what the court has said, and then what is it that we can able to do. It means that, Chair, we don't have capable state in Treasury to able to come up with the laws that will empower Black people. And then I think BBCBE must be able to take a position. Are we going to follow suit that we need to go to take government to court and force government to use laws to able to empower Black people? Look at the 80-20 and 90-10.
Mr. Dube, as you wrap up, we've got a lot of hands.
Yeah, but I'm just saying, Chair, the fact is that BBCBE and BBC cannot just have this continuous discussion without able to have a conclusion in terms of how we're going to work with government, while it's clear that this present government is not prepared to empower Black people and change laws that's going to favor Black people to advance in economic development. Thank you, Chair.
Thank you, sir. Can I just open the last one, because I think the last one was just a comment from Mr. Dube and a food for thought for us. Can I open the floor for Mr. Mpafa, Dumisani Mpafa, to make his presentation quickly? Mr. Mpafa, I'm handing over to you. As he's getting ready, can I then
I've just been unmuted, Chair.
Okay, okay, over to you, sir.
Lovely. Good morning. Thank you, Chair. Great presentation from Treasury. I'm going to run through one or two questions. The first one is a comment. I think Ms. Peterson, on the analogy of broad-based BE, I think you are correct to say your approach is very simplistic, because you must remember with broad-based BE, you know, we were moving away from the narrow-based approach, which benefited few people. Because you must remember, not everybody will get a procurement opportunity through the first tier, you know, opportunities. Some will procure, you know, as second tier suppliers, and also, you know, to broaden the benefit by actually allowing, you know, other enterprises who are not able to grow and participate in the economy to be given opportunities through enterprise development. And so there's money that's being spent to benefit Black people so that they can participate, but also thousands of people that are put on learnerships, which are Black people, who would then help them to participate in the economy. So if you displace BEE in the public procurement space, you actually, you know, will benefit few people in terms of procurement, because not everybody going to get procurement from the public sector, but also what it does, it displaces a whole lot of people that are benefiting as second tier beneficiaries in terms of BE. So that's very narrow and very simplistic. The other issue with the HDI that we seem to want to rely on, my understanding of it is that it includes white women, and I would want to invite your question on that, because then if white women are going to be beneficiaries in terms of the HDI, because they are historically disadvantaged, if you're going to use that terminology, and which would mean that white people still participate in the economy through their, you know, their white sisters and women and so on. The other issue on the draft regulations, quickly, I would like to invite your input on the significance of end in terms of section 3.1. 3.1, you got the preference points, and then you have end specific goals. So what's the significance of end? Is that you will then apply the 80-20 and you apply the specific goals, what's the significance of that end in that sentence? And then the other issue, such a quick comment, Chair. The BE.
As you conclude, Mr. Mpafa, as you conclude.
Thank you. The BE alignment with PFA until 2011 regulations, government never considered a broad-based BE in terms of submitting BE certificate and all that in terms of their procurement. And it's only through 2011 regulations that we started recognizing a BE. Now, if we're going to take away BE from through PFA, how are we going to make sure that government uses a broad-based BE? And lastly, chapter 4 that you're talking about was very problematic in the initial draft. Has it been revised? Because if it's going to be fast-tracked in the shape and form it was when the first public procurement bill came out, then we are even more in trouble than we are today. Thank you, Chair.
Thank you, Chair. Thank you, Mr. Mpafa. I'm going to hand over to Ms. Peterson and the colleagues at National Treasury to handle that first round. I already have the second round of questions ready. We have the Deputy President of the BBCBE, Mekile Mteto. We have Ndate Keza Koza, as well as Ndate Itumele Masala. I don't know if that's Prof. Masala, but if it's Prof. Masala, welcome, Prof. That will be the second round. Let me hand over to the National Treasury colleagues as the second round question participants prepare themselves. Ms. Peterson, over to you.
Chairperson, if I may, before Ms. Peterson comes in, may I?
Okay, is that Ms. Mashabane?
Yes.
Please proceed, ma'am. Please proceed, ma'am.
Yes. Just few comments before my other colleagues comes in. Chair, I think it's quite critical for the meeting to really appreciate that when it comes to transformation, we've got a whole lot of role players that have got different mandates, and until or unless those mandates are effectively actually are executed, it becomes a challenge when we try to zoom them using National Treasury and procurement, because even then the country doesn't get the best that it ought to have. Even when we have to remove the constitutional kind of provisions with regards to actually empowering those that were historically disadvantaged with BEE. We have to actually realize that there is something fundamental that we are removing out of the system, especially those that will not even have the money to actually get a BEE certificate. And it was interesting to actually see that shift happening so right in front of our eyes, where before 2011, it was a particular group in terms of doing the work, and not particular group in terms of exclusion, but in terms of how calculations were made. But all of a sudden, overnight, that group didn't have money for BEE certificates. It became a different group altogether. So how we do those things, how we merge these transformational agendas from various institutions is fundamental, that we don't use that to displace the other at the expense of empowering those that really need empowerment, and balancing that with our economic prerogative that we need to have in the country. So then, Chair, what I'm trying to say is that I think even BBCBE must actually also engage with other stakeholders within their line, because we need to stay in our lane. So what we are actually communicating today, that this is the lane of National Treasury. Do we all have the appreciation, starting from the Constitution, and also understanding that we've got organs of state? Yes, Chair, we heard that they really, we don't underestimate their reliance on National Treasury. That actually is a very unfortunate situation that has been created over years, when the Constitution has empowered institutions to have this policy. This is not the judgment that actually brought it in. It has been in the Constitution. So which means institutions that do not have that policy now has not been actually implementing their constitutional mandates. because what it means, they have to understand their area. They need to understand who they need to empower. And our policies and framework becomes a platform where they actually plug in and their policies find expression there. So yes, we understand the fact right now that that dependence is becoming very critical because everybody's actually saying National Treasury. But it sometimes you even wonder that when we look at National Treasury, do we fully understand the limitations of National Treasury and limitations in terms of law? Do we understand that there is an act right now that might not allow us to go beyond some of the things that we really love to do? So if we understand, so we need to educate ourselves. So because when you understand that limitation, that is, we then start having a conversation that will help us to benefit or to get as much from that limitation as possible could get. So it's important to understand, colleagues, that institutions can never run away from that which was their constitutional mandate from the time the Constitution came into effect. So they must have their policies. Yes, in terms of streamlining and unifying the whole thing, we've got the framework, which is the BBCBE. Yes, we understand that through the bill, it's going to be changed. So now it becomes an opportunity to make sure that the things that we are discussing here, they find themselves in the bill to make sure that the next bill or the next act that comes through in terms of preferential procurement actually addresses this thing, because now we've learned from the past. We have learned from the BE and also from the historically disadvantaged individuals in terms of how we want to actually empower them. So the issue of the BE chairperson, that is a DTIC issue, DTIC mandate. And when it talks to mandate, there's a different mandate, even though it's transformation. So when we engage here, how does it, where are the point of contacts between the BE and the preferential procurement as it requires by the Constitution? Let's get those point of contacts instead of totally replacing that which the Constitution requires with BE, because that is suicide to actually empowering those that will not even have money to go and get the certificate. For me to prove that I'm Black, I have to produce a certificate. And that is sometimes something that we don't realize the impact that it does when we actually replace this kind of issue. So I think all that I'm asking, Chair, is that let us be mindful of the limitations and of the mandate of various institutions and of the lane within which National Treasury needs to stay. As long as we stay in that lane, we will be empowered to do the best that we can, and then hold other institutions accountable for their transformational mandates. And then let's see how we all come together to make it work. But it's not something that is totally going to be in National Treasury. Not that we are running away, because the Constitution is very clear that organs of state has to do it. Our role is to provide the framework. So we need to be held accountable with respect to the type of the framework that we are providing to enable institutions to do what they're required to do. But what is critical now, what is at hand now, is that we have the regulations that are out there. With the discussions that we have, what are we going to do within the law to make sure that those regulations take us just a step closer to what we want within these limitations, in light of the presentation that Mrs. Peterson has actually given us? That kind of engagement becomes quite progressive in my view, because we appreciate the limitations, but we're saying let's work within them and holding every other institution accountable, and understanding, Chair, as well, the difference between PFA and
as you wrap up, Ms. Mashabane.
Yes, Chair. I think I can actually hold it there. I think I have.
Okay.
In a sense.
Thank you very much. Thank you very much, Ms. Mashabane. So Ms. Mashabane, what is critical is that we can't be frustrated, all of us, from government side and also from the beneficiaries, which are Black people sitting on the other side. We want to engage with government, and we are getting frustrated left, right, and center. And I think what you said earlier around the trying to expedite the introduction of the public procurement bill is what is important. And I think that's, again, the frustration that we have as beneficiaries on the other side, because had we introduced the public procurement bill timelessly, we'll have avoided some of these things. So we do again wish to request you, Treasury colleagues, to make sure that this public procurement bill, notwithstanding the reasons that have been advanced so far for the delay, that can we please expedite the processing and the introduction and the enactment of that bill, so that at least we can be able to cure some of these frustrations that we all have. I mean, we can't all be frustrated. We are frustrated. Government officials are also frustrated. There can't be frustration all around. We do have a solution. Let's implement the solution. Briefly, Ms. Peterson, can you just answer to the specific questions that were asked by the previous round, so that we can quickly move on to the next round of questions, please?
Yes, thank you, Chair. I think the issue around I think there was a specific question around the regulation 3. I think where the speaker asked, what does it mean, the significance of the word "and"? So if we look at regulation 3, it talks about an organ of state must, in the tender documents, stipulate the preference point system applicable to the tender as is envisaged in regulations 4, 5, 6, or 7, and any specific goal as envisaged in section 2(1)(d) and (e) of the Act. So what this is saying is that in the tender documents, the institution must say whether or not the 80-20 or 90-10 preference point system will apply. And then it must also indicate what are the specific goals that would be applicable in that tender. So for example, remember, it's now no longer a case of saying your BEE certificate now, it's saying your specific goal, so that in this goal, we're going to look at enterprises owned by Black people or persons with disabilities, or we're going to look at enterprises maybe that have manufacturing capability in the country. We're going to award 5 points for this, 10 points for that, and another 5 points for this. So that's what it's saying. So over and above indicating what preference point system would apply, i.e., would it be your 80-20 or your 90-10, it must then also indicate how your points are going to be allocated for your specific goals. So that's simply what that "and" is saying. So you don't only just say the preference points, you must also indicate what specific goals are you going to apply in that tender document. And then on the issue of white people, again, or white women, again, the issue is around who has been discriminated against. And again, it's not up to Treasury to then indicate that allocate points to white women in that tender document. You don't need to utilize that portion. For example, you can indicate which are the particular groups that you are going to allocate the points to. So the issue is not about excluding white people from procurement, and that's why I also indicated previously, as I think Mr. Mpafa mentioned, that's why I very quickly acknowledged the example being a simplistic one, but recognizing as well, as my colleague had stated, that we have different roles, and our role on that point is to look at historically disadvantaged individuals. There's a role to be played for broad-based Black economic empowerment, but that's within the mandate of another unit who very clearly, or where a press release was very clearly issued by the BBCBE Commission, the BBCBE Commission, that the removal or the fact that there's a judgment against these regulations does not stop the movement and the work of broad-based Black economic empowerment from continuing. So I think we need to, let's be clear, let's have a line of sight in terms of our mandates as well, but also recognizing, I think we need to also give credit where it's due, colleagues. And I think we have begun, Greg knows, Chair, sorry, knows very, very much how we have these debates and discussions and how we have developed thick skins. But I think it's also fair to acknowledge that Treasury has actually stood alone in this fight because it's Treasury who took a risk and introduced Regulation 4 and 9, which started the challenge. And Agribusiness, I must say, had various friends of the court joining them in defending this position. And Treasury, up until the Constitutional Court, stood alone. And we had issued we had indicated to people, please feel free to join as friends of the court. If you truly are concerned about the situation, feel free to join. Thankfully, there was one group that joined. It is a matter of court record, so I will say it. It was the EFF that joined, and they put up a very good argument also in favor of the regulations. So what I'm saying is, colleagues, it's easy to be disappointed. We're all disappointed by a number of things, but let's also step up and together let's hold hands and do what needs to be done. So I think that we have put something out there. We've indicated our limitations, but we've also said that it is important and to fast track the bill. And that's why we even said there's a call from some quarters that say, why don't we maybe even extract Chapter 4? And it's not in its current form, because I think the idea initially in that current form was to give a menu of options and to allow maybe the regulations to give detail. But I also think that from where we're sitting, that we're saying, if we do extract that, let's have a look at how it can be worded as a framework. And then let's even put the regulations out there at the same time so that people can have a sense of what the framework looks like, as well as the regulations. Let's learn maybe lessons and not box ourselves in. And one of the first lessons we had already identified was to put a preference point system in legislation might not have been the most prudent thing to do because it boxed us in. So we're saying with those lessons, let's see what we can do as a more meaningful way to allow for empowerment. Thanks, Chair. I really would like to allow my other colleagues to come in if needed, if they feel they need to, Chair. I don't want to let them feel that they're excluded. So if they want to, please, Chair, I'll ask that you allow them. Thanks.
Thank you, Ms. Peterson. In fact, we do have the hand from Mr. Thando Matebula to assist you there briefly, Thando, before we open the next round of questions.
Thank you, Chair. Maybe just to stress a point that was made by Sihle on the issue of around guidelines, the issuance of guidelines. I think we must be careful that we do not prescribe policy through the guidelines. And we must also understand that guidelines are non-binding. So if there are capacity issues, there should be other ways of seeing how we capacitate organs of state. That's the point I wanted to make, Chair. Thank you.
Thank you very much, Mr. Matebula. Mr. Matebula, I can assure you that our members are getting very frustrated out there, interacting with organs of state that do not have capacity and seem to be making irrational decisions insofar as procurement is concerned in this period. So I think what we are just requesting is that Treasury should look at how to advise them. We understand that we do not want to be prescribing to them or to be issuing instructions to them, but we think that just that advice will help, because some of them are really at sea. They don't know whether they're coming or going. You do know the capacity of our people, especially in municipalities. It is very bad. So we do need you to work closely with them so that you can assist them to navigate, because if they are confused, we will also be confused as service providers. So I think it's best that we are able to work together with those colleagues that are less capacitated than others, just to assist them to be able to be on the same page as yourselves, colleagues at the National Treasury. Colleagues, let me recognize the presence in our midst of our Deputy President, Mekile Mteto. Mteto, you are welcome. Thank you very much for your attendance and being here with us. Can I then give you the platform? You will be followed by Mr. Keza Koza. I see that Mr. Musala has decided to abandon the hand. We will then also have Mr. Frank Mahabani after Mr. Keza Koza. DP, over to you.
Okay, can you hear me now?
We can hear you, DP. Kindly proceed.
All right, thank you very much, and good morning to the colleagues. Mine is just a simple, straightforward question to the colleagues at National Treasury. And this is stemming from the fact that for the longest time, National Treasury has enjoyed the supremacy when it comes to providing guidance, when it comes to issues of the triple PFA. They've been the custodian, they've been the owners, they've been the police, and so on and so on. To a point that we are sitting here today with that practice notes number 15 or number 16 that we got at some stage that was sent by Kruger at some stage. So it is very disturbing now to say that in today, after we've got this Concord judgment, the National Treasury wants to kind of like distance itself from the situation because they have created the monster that we're dealing with right now. And it would help us a great deal, honestly, if we could say now that at least we know that it is the state organs that are supposed to develop their own policies. What is it that is supposed to do? Because the point and the fact of the matter is that state-owned organs are not capacitated. So as it is, they've been using the same National Treasury as a scarecrow when it comes to the application of the rule of the law. And National Treasury has come into defense to say, no, but you guys have got to do 1, 2, 3, 4, and nothing much has happened in terms of capacitating them. Now we are where we are. I would like to hear from the colleagues that given the current the procurement regulations that are drafted right now that we're supposed to talk to, what is it, what opportunity does this particular draft regulations offer to us that we can be able to look into? And what is it that we can be able to do us as well as the people that are affected by this kind of law in terms of assisting the municipalities and other state organs to ensure that this preferential procurement does actually take place, especially for Black people, for women, for people with disability, for the military veterans, and also for the youth, because we are the ones that need this particular preferential procurement more than anyone else. Thank you, Chair.
Thank you, DP. Mhlompe Keza Koza.
Okay, all right. Thank you, colleagues. And I would wear a different hat. I would wear a hat of being a member of the BLA and the BMF. And I've got suggestions because I've been in the public procurement space for the better part of my life. And this is not the first judgment, by the way. There was a KZN transport judgment, a Maritzburg judgment, as I refer to it, on a similar issue of 90-10, 80-20. There was a David's judgment in the Western Cape. So this is not the first judgment. It's just that this one is pronounced by the highest court. Others were binding in different jurisdictions where they emanated. Now, I just want to say, we need to be very wary of saying that organs of state must come up with their own policy. I have read the judgment by Justice Madlanga, and I have read that excerpt where he seems to be saying that. And I would advise, again, let's get proper legal advice just on that. Because Section 217(3), where the triple PFA finds its resonance from, is very clear that there must just be one legislative framework to achieve preferential procurement. It doesn't say anything more than that. So I wouldn't want us again to be taken by these counter-revolutionary organizations to court and for us again to be found wanting. So I would advise, and I've got a quick solution. Instead of waiting for public procurement bill that may take 3 to 4 years, because people are going to question each and every clause there is, why are we not in the meantime amending Section 2.1 of the triple PFA? Because that will be much more quicker and much more easier. We all know the biggest elephant in the room is 90-10 and 80-20. We all know that. The reason why we ended up crafting pre-qualification criteria, it is because the very same people we wanted to advance, who are the HDIs, we couldn't advance them with the 10, because that 10 will equally include white women and white disabled people. We all know that it has been frustrating for a number of state-owned enterprises as well as organs of state. And we know that. That's why we came up with the pre-qualification. Therefore, let's hold the bull by its horns. Let's rather, in the meantime, which would be much more quicker in terms of legislative drafting and process in Parliament, amend Section 2(1), 90-10, because that's where the problem is, and 80-20, and clean 2(1), instead of saying we are going to wait for a public procurement bill that would take 2 or 3 years from now. Now, I'm at the end, Mr. Mfugeng, and
Yes,
I just
sir.
want to say, the fact that government issued the 2017 regulations, some of us knew that we are acting ultra vires, because what we wanted to achieve is what the act was not enabling us to, right? And we should all agree that the problem is 90-10 and 80-20, that in the 10, and not even the whole 10, probably the 6, we seek to advance Black people, in particular Africans. So we need to clean that part instead of saying, let's rather bring chapter 4, which will be a new bill, because if it's a new bill and a new act, it will take even longer. Same as if we continue with the public procurement. Rather, let's amend. That would be my suggestion. And the last one, let's get proper legal advice on what Justice Madlanga has said. Because I argue, having read the judgment, that was not a matter before him. So he might have said it as an obiter dictum to say, why don't organs of state do 1, 2, 3? In no time, you would be finding yourself in court again, being challenged by saying, why is that organ of state doing things differently from that organ of state? Because we are now leaving it to different organs of state to do as they please. So others may advance the transformation agenda more better or far lesser than others, and it's going to bring confusion. And I doubt that that matter in particular was before the judge. It was never argued. It might have been an obiter dictum that he adds as part of his judgment. So let's not take that as part of the core issues that were debated in court. Thank you.
Thank you, sir. Thank you, sir. Mr. Makhabane? Mr. Makhabane?
Thank you, Chair.
Over to
Can you
sir.
hear me? Can you hear me?
Over to you, sir. We can hear you, sir. Please proceed.
All right, thank you, Chair. I think the bigger part of what I was going to say, my comrade Kaiser has actually alluded to the issue of seeking a legal advice quickly, and then bearing in mind that we as Black people actually, this law was actually passed with a very bold statement to protect our designated groups. And you would find that this actually, it takes away the same principle that we were trying to protect about our designated groups, being our veterans, being our disabled people, being our women, being our youth, and being fully aware that the system and the transformation is very slow and seeks to give certain people favor over others. And now removing this would actually take us back to, take us back to the little that we have achieved since 1994. So our prayers, it's us going back to seek a proper legal advice, and then coming back to try to bring back the principle and the law back to where it's supposed to be, and trying to advance the same people who were previously disadvantaged, being our designated groups, that actually needs the people who are office bearers to actually not take these things light, because we know that the system, it's even from previously, it has never favored the Black child. So we need to make sure that the little that we have and the wisdom that is given to us, people in the offices of power, we don't have to just say die and allow this to pass. If it comes to a push, we need to set up another law that actually clearly from inside, we clearly allow this principle to still continue if the first level of selection could be changed. So we need to come up with the quicker law that will be used within the departments to actually safeguard the principle in order to make sure that we still drive the mandate of transforming the economy and also looking after our designated groups. I thank you, Chair.
Sir.
Yeah.
Thank you, Mr. Mahabane. Colleagues, let me just use the powers vested in me to opportunistically include the very last hand, Ms. Sanele Umisa.
Thank you, Chair. Can you hear me?
Yes, Sanele, we can hear you. If you can be quick, my brother, we're almost there. If you can be quick.
No, Zobeg is so. I think what has been explained, it's what has Treasury been explaining for some time. I think in KZN, we did have a session where we invited National Treasurer to give us a brief, and they explained the same thing. The issue is that departments and other organs of states refuse to adopt certain policies because they are afraid that they're gonna end up being questioned and obviously transgressing with what is explained as law. Be as it may, what we've also noted as the Black IT Forum is that the formula itself, it's incorrect because it places a lot of emphasis on price. That is not obviously controlled by most of the previously disadvantaged individuals. If you go around and ask whoever is supplying government with services and goods, you'll realize that they do not manufacture, so they do not have control over what price they can offer. But most of the emphasis is placed on price. So that's a bit worrying factor because this formula has been used for several years and there hasn't been any consideration in re-looking at it so that at least the entire procurement process becomes fair. As it stands, we can argue matters of law and other policies related issues, but as long as you place 90% to someone who doesn't own any means of production, you're still gonna come up with the same answer at the end that they will not be able to participate meaningfully in the economy. That's the summary of obviously my points that I'm bringing forward.
Thank you very much. Thank you very much, Sanel. Ms. Peterson and the team from National Treasury, I just want to hand it back to you to answer this very last round of questions and to obviously give us a view on what Mr. Khoza was raising around the amendment of the triple PFA now, instead of or rather run it concurrently with the process of the public procurement bill. And then after that, we'll then introduce the president to make the closing remarks. Ms. Peterson, over to you.
Thank you, Chair. And I must thank the colleagues in the meeting for coming up with suggestions. I think this is the part of the meeting that's exciting, when it's about actual sort of ideas that we can throw around. Let me maybe talk to Mr. Khoza's question first, around oh, apologies, around the issue of maybe the justice's comment being part of the obiter dictum and not his ratio decidendi. I think for us, if we were listening, I'm not sure if you had an opportunity, sir, to listen to the court case in May. And if you listened there, you'd notice that the judge actually went into great detail about the whole concept of determination versus implementation. And the reason for this, and again, it talks to, and I agree, to the challenge around the triple PFA in the first place, to the way it was drafted. Because if we go back to the Constitution, it doesn't necessarily talk to determination. It talks to an organ of state implementing. But then it says that it must be done in terms of the framework that national legislation prescribes. And so that framework is what has been prescribed in the triple PFA. And in the triple PFA, not only is the 80-20, 90-10 a potential problem and has turned out to be a real problem, but also, at least from some quarters, the fact that the framework put the obligation and the right and the responsibility to organs of state to determine. So it didn't go on, it didn't just say implement, it said determine and implement. And that's why the justices went on very, in fact, even Justice Jafta, who was part of the minority judgment decision, went on very long about explaining the concept of determination. And so it was not, so it can't be, so from what they said, it definitely was part of the rationale for their decision and not necessarily just something in passing. But what we can, I think, agree on though, is that in part of what he said about organs of state determining their own policy, I think it cannot though be assumed that organs of state can determine their policy on their own. There is still then the aspect of regulations that need to be drafted for the very reasons that I went into length about in the beginning of the presentation. So I agree that it's not just a blanket sort of statement, organs of state determine your policies. Yes, it's there in the law, but it's determining them in light of the framework. And then secondly, around the issue of getting legal opinion, trust me, there's been nothing but engagement, if I can call it that. There's been lots of engagement with legal counsel. There's been discussions with legal minds in the industry. So this is not something that was thought of lightly. What I can also agree is that it has taken way too long for the legislation to change, in the sense that it's not something that was determined yesterday to be a problem or by the court decision. And that's obviously why there was the whole introduction of the recognition that there needs to be a procurement bill. Again, this is why, but if we look at, do we amend the triple PFA or do we fast track chapter 4 of the bill? I think a lot of work has, and a lot of comments have already come in on chapter 4. So the issue would merely be to rather look at those comments, as is being done, and base on what the comments have said, because I think a lot of the comments that have been made at this meeting are some comments that have been spoken to with regards to the bill anyway. And rather than fast track, and that's why I'm saying, because if you amend legislation, it doesn't, because it's a parliamentary process, unfortunately, it's not a fast process like amending regulations, because the regulations are in the domain of the executive authority, the minister, who can then do what we did now in terms of just promulgating in the gazettes, publishing in the gazettes, let them lie there for 30 days, look at the comments and fast track it. Unfortunately, even if you're amending legislation or writing new legislation, it's still the same kind of process that would be required, because you would still need to get comments from the public, you would still need to consider. And that's why I'm saying one of the options, because there was that consideration as well. And it was felt that, you know what, there's already a process that is gone quite a distance already. Why not just rather fast track that chapter? Because remember, that chapter then would then, or that legislation would then be the national legislation that is prescribing the framework. But I want to assure colleagues around the table that those discussions and those considerations have been looked at, and we appreciate. Oh, I did see something in the chat as well about, can we not appeal this judgment? Unfortunately, this is it. It cannot be appealed. It was a decision taken by the highest court of the land, who has pronounced on constitutionality of the issues. So at best, what we can do is what we are doing now in terms of going back to the court, and that is just to get the clarity around the suspension of the declaration of invalidity and that period. But beyond that, it's about now doing what is within our domain in terms of saying, okay, change legislation. And that is then, like I say, fast tracking maybe chapter 4. There was a proposal to look at maybe amending the triple PFA, but it has the same objective as what chapter 4 is seeking to do. And remember, that is why we've said the whole aim as well is to maybe not have a one-size-fits-all approach and just say, okay, here's a 80-20, 90-10. But of course, bearing in mind that there are also competing objectives that come to play. For example, I know there was a concern probably when the triple PFA was first introduced around what would that mean for the fiscus, et cetera, et cetera. So that is why it's a case of saying, okay, let's look at a menu of options. Maybe in some instances, there can be a provision for set-asides altogether. In other instances, there can be a system, but one that looks flexibly at things. So these are the kinds of considerations that are happening, and your comments, the various comments that have been received on that chapter have been well received and considered. So it would just be a case of, unfortunately, like I say, the team that is here was not part of the, it's not part of the drafting team on the bill. But given that there's this court case, we also have a vested interest in seeing how that unfolds. And so we have also been liaising with our legislation unit. So, but I really wanted to thank the colleagues for at least the thought that's been given into that and some of the suggestions, but to also assure you that those are things that we've been looking at as well. And yeah, I think the others were more supporting what has been said by Mr. Khoza. And then in terms of the regulations, I don't think I heard the question properly by the Deputy President. I'm not sure if my colleagues would have heard it. Unfortunately, at that time, I happened to be coughing a lot, so I do apologize. Either if maybe Chairperson, if you can just repeat it, or one of the colleagues can answer, I'd appreciate that. Thanks.
Just quickly, DP, can you just repeat your question very briefly so that we can be able to close? All right, if the DP is unable to repeat the question, I think
I am.
Oh, okay.
All right.
Over to you, DP. CEO. Over to you. Thank you.
Sorry,
DP,
what is it that you would like me to do? Sorry, I missed it.
Ms. Peterson missed your question. She just wanted you to restate it briefly.
Oh, okay. No, my question was based on the fact that we do now have this window period of looking at these regulations. What is it? What is the opportunity that we can be able to leverage using this in the midst of all of the madness that is currently happening? And then secondly, I was also talking about the way forward. If the state organs are empowered according to the Constitution to actually create or develop their own policies in this regard, what is it that Treasury is doing to assist them? Because we have seen in the past that they have declared themselves not being able or not being capable, and citing that Treasury is actually the custodian of the triple PFA. So yeah, I think let me just leave those two things.
Over to you, Ms. Peterson.
Thank you, Chair. I think my colleagues may have touched on that quite a bit earlier, but maybe firstly, just to quickly indicate, I think it's important as well, and this is a point we usually make, but I think we didn't maybe say it at this meeting, is that when we look at 217 as a whole, that talks about procurement and it talks about organs of state contracting for goods or services, I think what happened then in the breakdown in institutions was that there was now a separate dispensation looking at PFMA and MFMA, and then a separate one. So one looking at 2171, and then a dispensation looking at 2172. And so there was this fragmentation in the legislation. And obviously this is now what the bill seeks to do, to have one single piece of legislation that looks at everything. But in this fragmentation, you'll notice that in terms of the PFMA, apologies, and with the MFMA, there are regulations that are drafted, and there's norms and standards that Treasury is empowered to do, especially if you look at the PFMA in terms of it, unlike the triple PFA that talks about prescribed by regulations, PFMA talks about prescribed by regulations and instructions. And the PFMA also there's in terms of Section 6 and in terms of Section 18, there's duties that can be performed by the National Treasury as well as the Provincial Treasury. And so it's those, and therefore in Section 76 of the PFMA, there's that whole ability now to issue instructions. And so whereas in the triple PFA, there isn't that. Instead, unlike the PFMA, where the Treasury can then step in and issue instructions on broader SCM prescripts, in the triple PFA, because of what it said, organs of state determine their own policy, it makes it a very fine line if Treasury starts issuing norms and standards, as it were, in terms of what those policies could look like. We have been having forums with different organs of state, and we have indicated, because remember, at best we can do what is legally cognizable. And so and this is my colleague, Ms. Motseto is here, who has been engaging with organs of state as well and saying and encouraging them as well that National Treasury will happily host forums where institutions can come together and discuss what they want to do in terms of or how they are envisaging their policies would look like, and where they can have the benefit of interacting with their counterparts around what they perceive to be good practice, in terms of what can go into their policies. National Treasury, obviously, from a prescript perspective, is then at liberty to give advice around, or not advice, but interpretation around what a particular prescript means, if institutions want to then incorporate certain things into their policy. So we're doing what the court said in terms of saying, look at legally cognizable means of getting in the meantime, until, of course, as the DP has indicated, there is a chance, of course, in the meantime, before the new legislation comes out, like either the bill or chapter 4 of the bill as a separate piece of legislation in the meantime. But until that happens, to at least then, organs of state have actually got a lot of power now, and they can utilize a lot of the provisions that are already existing, but were just not in the minister's place to do. And that's why the idea is to say, okay, look, from our side, we can get people together, arrange a platform for them to interact with their counterparts, where they can share ideas around what the policies would look like. And so that at least, because remember, we're living right now in a very litigious environment as well. And it's costly and it's time consuming to, instead of being allowed to do the work, we spend time in court. And even the advisory communication that was issued to try and explain to organs of state what to do was already challenged. So we constantly, while we're trying to get on and forge ahead with the work, we're constantly batting off, attacks. So, but we then felt that at least if something like that is done, and those kinds of forums take place, and institutions were quite happy about that. And that's why even here as well, this is the team that is looking at the regulations, and the team that is then trying to ensure that institutions are on the same page around what they can and cannot do. My colleagues, please feel free to come in if there's anything else that I've left out. Thank you.
Thank you very much, ma'am. I don't know if there's any one of your colleagues that wants to come in, but we are over time already. With your permission, let me just make the announcement that all those participants who have posed questions that were not answered, please do give us your email addresses. We are going to consolidate the questions that were not answered and submit them to National Treasury. And once they respond, we're going to distribute them. So we will distribute those responses. So we'll appreciate it if you can send us your email addresses so that we can then be able to communicate with you as soon as we receive those responses. If there is no other hand from National Treasury, I will then bring on board the president at this stage and allow him to then do a vote of thanks. President, over to you.
Thank you very much, CEO, who's also the Vice President of BBC. And indeed, let me start by thanking yourself and your team for having put this webinar together. And having looked at the number of participants, at one stage were over 160, that indicates the type of interest that discussion, is drawing. And on that note, I think we might need to organize a workshop where we will consolidate all the inputs as a submission from BBC, and not really discouraging individuals to submit their inputs. And what has come forward is that maybe as a reminder that this comment is closing on the 11th of April 2022, and the email has been provided, comment draft legislation at treasury.gov.za, and that is very key, that we respond in numbers. And I just want to tap, without wasting time, on the issue that has been raised, the friends of the court. And it is up to us, colleagues, as Black business, to try and address that gap. We know that there are financial constraints, because there is an amount that you have to pay to be the friend of the court. But I think in matters that really affect us, we really have to try and make sure that we become participants, in that space, instead of being reactive. And going straight into, thanking all the participants who were part of this. And I hope that when we cry out loud to invite you for the final workshop before we consolidate our report, before the 11th, you'll attend in numbers. And I'd like to thank, the panel. You will pardon me if I don't mention your name. I don't have the whole list here, but I've seen that there were about 9 panel members. In particular, to thank, which something that gave me hope and courage, that today we were led by women, and we know that when we are led by women, Gaspedi, where I come from, bare Marangwana utshwara thipa ka bogaleng, and then taetwa ke tshadi pele di nomasi. So we believe that the nomasi from this process. Mayor Leander Peterson, thank you very much for having provided with that much needed information, and Mayor Mashabani and the rest of your team. Thank you very much for that effort. Colleagues, we've gone beyond the stipulated time. I'm not going to go into details, and I'll also like in general thank everyone who participated, and including our Deputy President, Mekile Mteto, for attendance. So on that note, colleagues, thank you very much, and the session is closed.